Good evening. Happy Thursday. Happy pre-Friday. Um, so I watched a video from Frog, and I thought it was an excellent video. I mean, his sound quality sucks, but he's getting a new mic, and I really appreciate that. So thank you, Frog, for investing in a new mic. But the interesting thing that I thought about the whole Decastro versus Wagner thing was how everybody, I don't know, kind of seems like they're judging Chile because the case was dismissed. The the defendant's motions were granted, and the case was dismissed. And I don't really see it that way. I mean, it was a doomed case from the get go. It wasn't a matter of if Chile was going to lose that case; it's a matter of when. Even a first year family law attorney like me who failed the bar exam 17 times or something like that. I don't remember exactly how many times I have been accused of failing the bar exam, but it's a pretty hefty number. But if someone like me can instantly tell that there's no hope of success, then I don't know why anybody else uh, would think that would think it's a big deal that this motion was granted. I mean, the problem is that Chile did not have any cause of action. There was no liability on the part of the defendants. I think a much better, well, okay, so I could criticize Chile for his shitty attempts at law and motion, and I could criticize Chile for his bringing the lawsuit in the first place. But even the bringing the lawsuit in the first place doesn't really indicate his ability, because I have worked with an attorney whose motto is that all, and he means it, all cases have settlement value. And I have seen him, this attorney, 50 plus years of experience, get settlements on cases where there is statutorily, as a matter of law, no liability. I've seen him get money out of insurance companies where the insurance company was protected by two separate uh, defenses, like two separate legitimate defenses, and he still got money out of the insurance company. It just, it never ceases to amaze me, his ability to do that. So uh, I'm looking for something, and I'm kind of stalling for time while I'm looking for it. So the real interesting thing is going to be the no one's really feeding me anything on the California state case, so I'm not really keeping up with that very much. But the real interesting test, I think, for Chile's ability is to prevail in Las Vegas. And the reason why I say that is because Chile has alleged that one of the cops punched him in the nuts, and that's something that is going to be down to a matter of proof. A matter, it's that's a factual issue. If Chile got punched in the nuts, there is a high probability that that is excessive force, unreasonable excessive force. If Chile was handcuffed and punched in the nuts, probably excessive force. Now, if his nuts got tapped while they were checking his ball sack area for a weapon or something, maybe it's not. But if someone knuckled up and, you know, put their back into swinging for his testicles, that that's something that's probably going to be a excessive force. So that's going to be the case where if he can't get that at least to trial, then that's what's going to look really bad for him. But that wasn't the interesting thing in Frog's video. The interesting thing in Frog's video was this case. And this was apparently this Christopher J. Cordova is a auditor. And one of the things that I have heard constantly, I have maintained, and I still maintain that you do not have a constitutional right, a cognizable constitutional right to film in a Social Security Administration office. The the test that would be used there is the Adderley versus Florida test. I've gone over this time and again, and I've gone over the whole. They use the same language as the God GSA memo, and it uses a lot of the same language as it is used in Poster 7 and in the CFR for the post office. And I've gone over and over and over again about how you probably can't film in they could probably prevent you from filming within the boundaries of the First Amendment. They could probably prevent you from filming in that area because it is a rational basis test. It's Adderley versus Florida. And so I checked the case. The guy got convicted of filming in a Social Security Administration office, and Frog was going over his sentencing or the USA's case for sentencing. But I went and I checked out to see if this Christopher Cordova had challenged the First Amendment. As being unconstitutional, the rules against filming in the Social Security Administration. So he did file one. This is his motion to dismiss, filed before the trial. He's been charged with 2 offenses: failure to comply with official signs, and the unlawful taking of photographs in public buildings. They stem from his recording at the SSA office, yada yada. So he says that it's facially unconstitutional. This provision is facially unconstitutional. It prohibits the act of recording under certain conditions in spaces occupied by federal agencies. Because of the act of challenging implicates the First Amendment, this is a restraint on freedom of speech. He challenges constitutionality of this regulation on, I assume, somebody's doing a little bit of hunting. Hey. Yes, somebody's hunting. It happens. So he challenges constitutionality of this regulation on federal property, in particular space occupied by a tenant agency for commercial or non-commercial purposes. Video recording is unambiguously speech creation, not merely conduct. And this is the Irizarry. This was an auditor. Animal Legal Defense Fund versus Kelly, yada yada. They're both 10th Circuit cases. There's practically universal agreement that a major purpose of the First Amendment was to protect the free discussion of governmental affairs. This purpose enables the press to serve as a powerful antidote to any abuses of power by government officials. Filming the police and other public officials as they perform their official duties acts as a watchdog of government activity and furthers debate on matters of public concern. As the First Circuit noted, an important corollary to this interest in protecting the stock of public information is that there's undoubtedly a right to gather news from any source by means within the law. That's dicta from Glick versus Cuniff. Accordingly, the question is whether an individual may record on public land implicates the First Amendment. Now, there's a couple things here. They're mixing a lot of stuff. Whoever the attorney was digging deep trying to get something. And filming the police and other public officials. A public official isn't a secretary or a clerk or something like that. Police officers are considered to be public officials, and other public officials are going to be like decision-making entities, like mayors, like board members for the city or county board members or whatever. So this is really an apposite, and there has to be some sort of a news purpose. So, so what is the matter of public concern, in a social security office? What's the matter of public concern there? Those are matters of private concern, whether or not an individual qualifies for Social Security, how much, etc. And gathering news. What sort of news are you gathering? There's no news there. There's nothing newsworthy. The First Amendment, as applied to state and local governments through the 14th Amendment, provides that state actors shall make no law abridging freedom of speech. Now, I don't understand why they're talking about the 14th Amendment here, because the Social Security Administration is a federal agency. And the 42 CFR that they're discussing, or 41 CFR, is a federal regulation. The First Amendment applies not only to legislative enactments, but also to less formal government acts. The extent of the government's ability to restrict protected speech on public property depends on the nature of the forum and whether the speech restriction is content-based or neutral. That is a valid point. The nature of the forum. So are we going to get a good forum analysis, right? In determining the nature of the forum, the Supreme Court has divided public property into traditional public fora, designated public fora, and non-public fora. So what is a Social Security Administration office? Traditional public fora are that the government has the highest burden, yada yada, narrowly tailored, yada yada. The second category is a designated public forum, is one created by the government by intentionally open a non-traditional public or a non-traditional forum for public discourse. Neither party contends the areas at issue were intentionally open for public discourse by the city. I don't know why we're talking about the city. This is a Social Security Administration office. He was charged with failure to comply with official signs under a federal law, recording at the Social Security Administration office. I don't know what the fuck they're talking about. This is just weird. I haven't actually read this part. I've read the decisions, but I haven't read his motion yet. So the third category, non-public fora, is any that aren't open by tradition or designation a forum for public communication. The government has greater latitude to regulate speech in non-public forum. A restriction in non-public forum, whether or not content neutral, will be upheld if it is reasonable in light of the purpose served by the forum and is not an effort to suppress expression merely because public officials oppose the speaker's views. So it has to be viewpoint neutral and reasonable. Rational basis review. And so is it reasonable for the government to restrict filming in a Social Security Administration office where people are doing things like discussing their Social Security numbers and other identifying information? The public land at issue in this case falls in the third category. The question is whether the restriction is reasonable. The issue here is this broad regulation that applies to all public buildings. The issue is that this is a broad regulation that applies to all public buildings. It applies to all buildings owned or leased by the GSA. It doesn't apply to all public buildings. It applies to all buildings owned or leased by the GSA that aren't fully occupied by a tenant agency. If it's fully occupied by a tenant agency, then the tenant agency's rules would apply. So that statement is not accurate in this motion. It is unclear what purpose is served by the forum because each forum may be wildly different. It is unclear what purpose is served by the forum because each forum may be wildly different. Well, so again, they're unclear. The GSA is basically like a landlord for the U.S. government. It owns and leases properties. And then other agencies, generally speaking, other agencies, although they might rent out space in these buildings to non-federal agencies, they might rent it out to state agencies, and they might even rent it out to commercial businesses like non-state actors. But the regulations that are promulgated in 41 CFR are for the common areas of these buildings. Moreover, as opposed to other forms of expression, the act of recording is silent and non-disruptive, except it is disruptive especially if you want to give someone if you want to tell someone your social security number to answer their questions, and there's some jackass behind you with a camera that also has a microphone, and they're trying to record your private discussion about your private financial matters and private personal identifiable information. Accordingly, this regulation is not reasonable as there's no defined purpose served through this restriction as applied to all public buildings. That was a shit argument. That was absolutely a shit argument. All right, and then 41 CFR 102-74.420 was vague as applied. So on its face vague, and then as applied. No, on its face unconstitutional, and then as applied vague, and therefore unconstitutional. Criminal offenses must be defined with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary discriminatory enforcement. Yeah, so we have a policy that you can't record in our space, and we have signs posted saying you can't record in our space, and we have security officers coming up and telling you you can't record in here, but this is vague? Like, how the fuck is this vague? I can't wait to get to this argument. When challenging a regulation for vagueness, the relevant question in a void for vagueness challenge is merely whether the defendant before us had, quote, had fair notice from the language of the law that the particular conduct which he engaged in was punishable. How the fuck was this not? Holy Jesus. Here, it provides an exception to the general rule prohibiting recording on public land. So this general rule, and then there's an exception. It permits recording in the common areas for news purposes. For news purposes. Defendant was recording and live streaming for news purposes. Well, I mean, because you say he was, what newsworthy event was going on there? ECF is electronic filing. I forget what the C stands for. It's what federal courts use to file electronically. Electronic court filing. This is the only question whether or not this carve-out applies to him. In this case, the area he entered into was a large waiting room. Let me look at this list of things. Was there a waiting room? No, waiting room isn't in the list. A reasonable person may understand the term lobby to include this area, an understanding of which defendant had indeed possessed, except he was told it wasn't. As defined by the Cambridge Dictionary, lobby is a large open space just inside the main entrance of a public building, such as a hotel, office building, or theater. Similarly, the Britannica Dictionary defined lobby as a large open area inside and near the entrance of a public building. As these definitions make clear, the lobby includes an area inside the entrance of a public building. Here, the defendant was arrested immediately after entering the facility. At the very least, it is unclear from the language of this regulation whether defense conduct was specifically exempted or not. Well, again, I like to rely on this part. This is you have to read a statute or a regulation in such a manner as it makes use of all of the language in there. The drafting body would not have put that language in there if it wasn't intended to be there. Accordingly, defendant was denied the fair notice of the law's demands. On this basis, alone the charge against the defendant should be dismissed for unconstitutional vagueness. So that was the motion. And then this is the order on the motion. He filed the motion to dismiss. He's charged with failing to comply with official signs and the unlawful taking of photographs in a public building. As a general background, he was at the Social Security Administration office, intending to record video and stream it live over the internet. When defendant went from an entryway to an interior office while continuing to video, security officers arrested him. Well, there you go. So according to the court, he went from an entryway into an interior office. So how does the court get there? In his motion, he first contends that this one is facially unconstitutional under the First Amendment. He acknowledges that his freedom to engage in free speech in non-public fora engenders the greatest latitude by the government to restrict. He also agrees that the location at which he was arrested was a non-public fora. I find his arrest was pursuant to a constitutional exercise of a government regulation. He also challenges that this other one is unconstitutionally vague as applied, and that it leaves it unclear whether his conduct was in a building entrance, lobby, foyer, corridor, or auditorium, locations where the regulation does permit recording. Based on the record currently before the court, The defendant was arrested in a place where he could be recording SSA interior space where SSA customers had personal information, such as social security numbers, in the open. The space was a more interior type area than those permitted by the regulation. The current record also demonstrates defendant's knowledge that he was recording in a public area. The defendant has not established unconstitutional vagueness here. He could re-raise it at trial. So then what happened at trial? Well, at trial, he apparently re-raised them, and we have the verdict. The matter came before me at a bench trial, so there was no jury. That's what bench trial means, that the judge was the finder of fact. The information charged 2 counts, failing to comply with official signs and unlawfully photographing federal property. The underlying facts are not disputed. Mr. Cordova went to the offices of the Social Security Administration. He used a video camera as he entered the building, being a self-described journalist. This was an ordinary business day during normal work hours in the SSA office, where SSA employees, persons seeking SSA's assistance, contract security officers, and Homeland Security uniformed officers. Virtually the entirety of Mr. Cordova's experience in the SSA office that day, and certainly anything of relevance, was recorded, and material portions were replayed during the trial. The SSA office is a freestanding building with the SSA as the sole tenant. So I wouldn't even think that you could film the if they're the sole tenant, then there's no space. One of the CFRs, one of the 41 CFRs, says that space controlled by a tenant agency is subject solely to the tenant agency's rules, policies, procedures, etc. As one enters the building from the outside through exterior glass doors, there is a rectangle space of perhaps several hundred square feet with no furnishings of any kind, with plate glass windows at the fore and aft, and frame construction on the left and right. The glass in the space had tape signs in several places stating that photography and videography were prohibited, citing federal law and SSA policy. The signs bore the SSA's official seal. There is also a sign posting the SSA office's hours of 9 to 4. As one walks through this first space, there's another set of glass doors. These interior doors lead to the office space in which SSA employees do business with the public. Immediately inside the office space, on the left are chairs for waiting customers. The rest of the office space includes desks, tables, other chairs, a check-in kiosk, and 5 stations marked A through E with partial walls between each, at which customers approach and talk confidentially with SSA's employees who are behind glass windows. On the day in question, Mr. Cordova entered the exterior glass doors and filmed inside the first space. He was there perhaps 3 hours. Although contract and uniformed law enforcement officers were with him much of the time, they did not impeding his filming or monologue. Because there were large plate glass windows on either side of the space, Mr. Cordova was able to freely film what was occurring beyond the interior second set of glass doors. He filmed persons going in and out of the office, persons sitting in the office, and persons being assisted by SSA employees, with virtually an unobstructed view of the entirety of the office area. At a defined moment during his visit, Mr. Cordova declared his intention to walk through the second set of doors into the office area and continue filming. The officers who were present informed him that that was against SSA regulations, and he would be arrested if he proceeded. The posted signs informed him of the same prohibition, and he was shown a copy of the actual regulation. Mr. Cordova testified at trial that when he went to the SSA office, he already knew the regulation and its contents. Further, immediately inside the interior, second set of doors was an obtrusive sign on a stand stating personal electronic devices, cell phones, cameras may not be used to take photographs or to make video recordings. This sign also had the official SSA seal. Mr. Cordova indeed entered the SSA office while filming and monologuing and was arrested at that time. These charges ensued. First, I begin with the proposition, although not raised by either party at trial, that the regulations in question purport to impose criminal penalties. These regulations jurisdictionally form the proper basis, yada, yada. Second, I would assume that the ordinary meaning of the regulations language expresses its purpose and enforce it according to its terms. When called on to resolve a dispute over a law's meaning, this court normally seeks to afford the law's terms their ordinary meaning. I believe this applies with equal force to interpreting a regulation. As the Supreme Court has noted with regard to federal regulations, a court must apply all traditional methods of interpretation to any rule and must enforce the plain meaning of those enforce the plain meaning those methods uncover. The 10th Circuit has further stated when interpreting regulations, we begin our analysis by examining the plain language of the text of the regulation, giving words their ordinary meaning. See, this giving words their ordinary meaning thing, that means that in the LMVPD case that Wallace has, he's saying approach with guns drawn. Well, you have to give those words their ordinary meaning, and that means that you're not alleging that the oh, I need to go over Wallace too, don't I? That means the court is going to give it its ordinary meaning and say that that does not mean that it was being pointed at his head. If the meaning of the text is clear, our endeavor is at an end, and we must enforce a regulation in accordance with its plain meaning. Unless there is a clear manifestation to the contrary, general words, not specific or limited, should be construed as applicable to cases or matters of like kind with those described by the particular words. Finally, both Supreme Court and 10th Circuit commonly rely on an ordinary dictionary to determine the meaning of a law's wording. So count one alleges he violated 41 CFR yada yada. Under that section, persons in and on property must at all times comply with official signs of a prohibitory, regulatory, or directory nature and with the lawful direction of federal police officers and other authorized officials. Based on my analysis of count two, see below, I find beyond a reasonable doubt that the SSA law enforcement officers gave Mr. Cordova lawful directions not to film in the SSA interior office and warned him he would be arrested if he did, yet Mr. Cordova failed to comply. Mr. Cordova also failed to comply with official signs of a prohibitory, regulatory, and directory nature. Incidentally, unlike the language in the following regulation under count two, Mr. Cordova does not challenge the meaning of these words. So count two alleges that he violated this one, which prohibits photographing space occupied by a tenant agency without permission of the occupying agency. It permits photographing in these areas. So that's, again, I'm going to disagree a little bit with the court's analysis, and I would say that since it prohibits photographing of a space occupied by a tenant agency, that would control, and then, but if it's not occupied by a tenant agency, then you can permit photographing the other areas. I accept Mr. Cordova was filming for news purposes. I don't, but the court could accept that Cordova was filming for news purposes and still reach the decision that the court wanted to reach. So was Mr. Cordova in quote space occupied by end quote the SSA, or was he filming in a subsection C space at the time he was arrested? I start with subsection C. From the textual presentation in the regulation, subsection C is clearly intended to address a different physical space than subsections A and B describe. The spaces identified in subsection C appear to describe a series of like-kind words and should be interpreted as such. I agree with the following pertinent explanation. Ejusdem generis, I probably butchered that horribly. Ejusdem generis refers to the principle that when a general term follows a specific one, the general term should be understood as a reference to subjects akin to the one with specific enumeration. Relatedly, the doctrine of noscitur socis, I probably butchered that as well, raises the implication that the words grouped in a list should be given related meaning. Together, these rules instruct that words in a series should be interpreted in relation to one another. The Merriam-Webster dictionary is this court's weapon of choice, and entrance means a place, means or place of entry. Lobby, a corridor or hall connected with a larger room or series of rooms and used as a passageway or a waiting room. Foyer, or foyer, depending on how you want to pronounce it. An entrance, hallway. Corridor, a passageway, as in a hotel or office building, into which compartments or rooms open. Auditorium, the part of a public building where an audience sits. Under all the interpretation rules and methods described above, I do not hesitate to ascribe to the first four a meaning that encompasses the first space into which Mr. Cordova entered on August 2nd, 2022, the glassed entry space where, logically, persons seeking to do business with the SSA would collect themselves, wipe their feet, brush off snow, or otherwise prepare to enter the SSA office. No SSA business would logically occur in the space, nor did any occur during the hours of filming on August 2, 2022. At first glance, the word auditorium has an apparently different meaning than the previous four words, but when applying ejusdem generis and noscitur socis in the context of this regulation, it describes a space in which the public congregates but would not be engaging in individual personal transactions with the occupying agency, corporation, school, church, theater, or other organization. On the other hand, through that interior second set of doors, the SSA conducted its primary business of assisting the public. During Mr. Cordova's filming, members of the public, including children, were indeed conducting business there. People were waiting in chairs, or people were in chairs. People were in chairs waiting for their turn. A customer check-in kiosk with a video screen was there, along with other indicia of a typical office setting. Mr. Cordova argues that this regulation is unconstitutionally vague in employing the terms defined above. He contends that the area in which he was arrested could reasonably be included within subject section C list. I disagree under the facts and circumstances of this case. The 10th, so he's limiting the holding to this case as he has to, since he's the trial judge and on the Court of Appeals justice. The 10th Circuit in the Baldwin case is noted in this regard. The Supreme Court has told us repeatedly that the relevant question in the void for vagueness challenge is merely whether the defendant before us, the specific defendant before us, had fair notice of the language of the law that the particular conduct in which he engaged was punishable. It is clear, based on the regulation, the signage in the SSA entryway, the instructions given by law enforcement, and Mr. Cordova's own understanding of the law, that he had fair notice of the law and that his conduct in filming beyond the interior glass doors was punishable. The facts established he knew that the SSA and its law enforcement officials interpreted the laws prohibiting filming inside the second set of interior doors where the SSA was conducting business with its customers. He had fair notice of the language of the regulation and that his conduct would be punishable under the government's interpretation of it. Granted, he has a philosophical disagreement with that interpretation, for which he was prepared to, and in fact expected to be, arrested. Although I respect his right to challenge the law and test his constitutional rights to their outer limit, he is wrong in this instance. Under a different set of facts, where a person might enter from the outdoors directly into a federal office, the outcome could be different. Here, there was a distinct entryway from the outdoors, corresponding with a subsection C space, after which there was a set of interior doors leading to a distinct and unmistakable office space, corresponding with subsections A and B. Without the SSA's permission to film in this space, which Mr. Cordova did not have, he violated the law. For these reasons, I find beyond a reasonable doubt that he entered into an on federal property and unlawfully photographed space occupied by a federal agency without permission, in violation of that. So he's guilty. So for all those fine folks out there who think that you can go ahead and film in SSA cases, I'm going to go ahead and say you probably don't want to do that. Now, we have had another document that was apparently filed today. This is Wallace. I'm sure this is going to be an amazing. This is a motion for leave to file a surreply in opposition of LVMPD's motion to dismiss. I have not read this, so let's see what we got. It's 5 pages. I don't know why you need 5 pages for leave to file a surreply. And was the surreply attached? And there was no surreply attached. Well, sloppy lawyering there, Chili. I moved to file a surreply. So the way it goes is you have the motion, you have the opposition to the motion, you have the reply to the opposition, and then after the reply to the opposition, that it's typically so the moving party gets the first crack and the last crack. And even in oral arguments, the moving party opens and then generally gets to finish at the end. A surreply is generally not allowed because the moving party is supposed to put everything on the table in their motion. The non-moving party puts everything, like they're supposed to crush all those arguments, and then the reply, because the non-moving party may have come up with some law or something that they're interpreting novelly. It might require something on the moving party's part to make the court aware of the moving party's interpretation of that. But it's not supposed to be a back and forth forever. The way it works is motion, opposition, reply, and then maybe a surreply if the court thinks that there's something that surreply might add. And then there could be a surreply. It just gets stupid. And normally the court cuts it off and does not allow it to go on forever. So cert reply, if granted, would be no more than 8 pages and cover only the issues newly raised in LVMPD's reply. Memorandum points and authorities. The court may allow leave for a cert reply. Courts in this district have allowed cert replies to address new matters raised in a reply to which a party would otherwise be unable to respond. Sure, that makes sense. Defendant LVMPD has raised several new issues in its reply, which I cover below. Oh, Jesus. All right, well, I'm probably going to have to do this then. And we're going to open that up in a new tab because I'm probably going to have to pull up other things. So we're going to switch to this tab instead. And I'm probably going to have to pull up other shit. All right. Why do we have A twice? I guess it's supposed to be B. LVMPD newly argues reply at 6:21 to 24 that I must first establish that LVMPD lacked probable cause before raising an unreasonable search and seizure claim. All right, we're going to page, what was it? 6:21 to 24. He's not pled facts supporting a constitutional violation against. So we're talking about the Monell claim. Right. So the argument here is that if the officers had probable cause to make the arrest, then under Bartlett versus Neves or Neves versus Bartlett, I always forget which way it goes, then the arrest is justified. If they have probable cause that Chile committed a crime, then the arrest is justified. And there is no Monell at that point because there has to be an unjustified arrest. Because if it's justified, if the cops had probable cause, then there is no, yeah. So they're saying because reasonable suspicion, probable cause exists, this claim fails as a matter of law. Let's look at their motion to dismiss. Let's look at the motion to dismiss. And we're going to download this, and we're going to open that up, and we're going to let's see if they address the Monell. Let's do this. Let's see if they address the Monell claim. Cause of action. It's the 4th cause of action. Monell claim must be dismissed. Wallace argues the officers lacked reasonable suspicion to detain him. So this was their they addressed it. Their reply in their reply brief. They're going back over what they were going over in their original motion, their 12B6. In response, the officers detained. Blah blah blah. Constitution does not guarantee the guilty won't be committed. The law is clear. The law is clear. The police officer is not liable for false arrest as long as the facts and circumstances, yada, 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 as long as you have probable cause. That's a fun way of saying probable cause. The probable cause requirement, or the requirement of the presence of probable cause is not one of absolute certainty, but of fair probability. So their argument here is that they had probable cause. Here you go. There's the argument. They had probable cause. So this So this is not a new issue of law that they're arguing here. This is was it contained in their initial brief. Where this circuit is held, defendants must prove probable cause, and that is a question of fact. This makes no sense. So U.S. versus Cervantes. This looks a lot like a criminal case, but let's take a look at it. So this is a motion to suppress evidence. Why are we talking about a criminal case? So warrantless searches by law enforcement officers are per se unreasonable under the Fourth Amendment, subject to few yada yada. Okay, so where's he citing to in here? Let's fucking find it. 804. 804. All right, here's 804. What does he say? Defendants must prove probable cause. So this is first of all, this is a criminal case, and it's not up to the defendant in a criminal case to prove probable cause. It's up to the state or the government. It's up to the government to establish probable cause. In this case, they found that it was a close question, but they found the officers had probable cause. Oh, Hankel's observations regarding Cervantes' benign travel tactics, when coupled with Hankel's conclusory statements about the box in Cervantes' possession, are insufficient to establish probable cause. This is only reinforced by Hankel's request that officers Coley and Sanchez develop a lawful reason to stop Cervantes. Had probable cause existed to stop Cervantes, there would have been no need to develop an independent reason to pull Cervantes over. This case is so not applicable to. Like, what the fuck are we doing here? That is a terrible argument. You're citing a criminal case with a different fact pattern and a different status. The criminal case was a motion to suppress. Motion to suppress. This is not a motion to suppress. I don't know what we're doing here. I'm sorry. I don't know what we're doing here. Opposition defendant's motion to dismiss. LVPD newly argues that I failed to oppose LVPD's motion to dismiss. Reply. We're going to look at the reply 14 to 16. This is page 4, right? Hold on. Reply 14, failed to oppose LVMPD's motion to dismiss. 15 to 16, I guess. Here, Wallace has chosen not to oppose LVMPD's argument regarding his equal protection-based claims, First Amendment-based claims, 1981 discrimination law, So what they're saying is it Wallace has chosen not to oppose the arguments. He's not actually provided an argument in opposition. Just saying I'm opposed to it doesn't work. So he's failed to provide the court with any additional facts or law to liberally construed. So yeah, he's just said you have to liberally construe it, but he hasn't actually provided them with what to liberally construe. It is not my responsibility to address all 200 of LVMPD's errors. Yeah, it actually would be. Like its laughable claims that filming a quote prohibited area end quote from public is illegal and a crime known as attempted trespass. I don't think it was the filming that they had a problem with. It was his. It was they had. I believe they felt they had probable cause that he was going to attempt to trespass, and that filming and approaching was a step in a step towards committing the enough to get the attempt. How about whether someone illegally detained must identify themselves? How about it? Like what is that? So, well, let's back up to this one. You'll notice, and I noticed, and the court notices that Chile did not quote uh, LVMPD's error and cite to it. Chile did not quote LVMPD's error and cite to it. Chile did not quote LVMPD's error and cite to it. See these? These are citations. How about failing data police investigation is the same as an overt act to obstruct? How about it? How about it, Chile? Excuse me, Wallace? How about it? How about it? Where's the citation? Where'd they say it? And why didn't you respond to it if they did say it? It's yes, it is your job. If they make an allegation of fact or law that you disagree with, it is literally your fucking job to say no, that is an incorrect interpretation of facts and or law, and to say why. You stupid idiot. What do you think lawyers why do you think lawyers get paid so much? It's because we interpret the facts in the law and we make sure that we respond to everything. My complaint is well pled. That's a conclusory fucking statement. I clearly oppose every one of their factual assertions. Wait, hold on a second. Hold on a second. It's not your responsibility to do it. Encounter with the actual facts in the complaint, and I clearly oppose their motion to dismiss. You didn't oppose the arguments made in their motion to dismiss, is what they're saying. Whether you did or didn't, I guess that's going to be up to the judge. If they really mean to rely on their errors, they could put them in an answer. They've already filed an answer, and in their answer, they denied all your allegations. But their errors don't make my complaint invalid. No, your errors make your complaint invalid. Moreover, LVMPD newly cites Keenan versus Allen, a Ninth Circuit case, where the plaintiff did not identify evidence that precluded summary judgment. Where did they cite Keenan versus Allen? Oh, here we go. It was right on this page. In essence, Wallace is improperly asking the court to scour his complaint to help him come up with arguments or facts to defeat LVMPD's motion, noting that it is not an appellate court's task or that of the district court to scour the record in search of a genuine issue of triable fact. So that is what they cited it for. That is what they cited it for. Now, what does Chile cite it for? Where the plaintiff did not identify evidence that precluded summary judgment. You don't identify evidence, you allege facts. But let's see if they talk about identifying evidence that precludes summary judgment. Keenan filed the charge the same day with the EEOC, alleging he has presented no evidence that a right to sue letter was ever issued. Okay. A grant of summary judgment. That is a jurisdictional issue. You can't sue for a violation of age and sex discrimination until you go through the EEOC, and they have a certain amount of time to deal with it. So they do. This court does say it's evidence, which is interesting. Only if the facts, the allegations of fact, read in the light most favorable to the non-moving party, demonstrates there's no issue as to any tribal or any material fact, and the moving party is entitled to judgment as a matter of law. Supporting opposing affidavits shall be made on personal knowledge, set forth all such facts as would be admissible in evidence, and so the supporting opposing affidavits have to set forth facts. Now, one thing that I do want to note is that this is a summary judgment. So summary judgment, the court does actually make findings of fact in it, as opposed to a motion to dismiss, 12B6 motion, where there will not be, the court just has to rely. That's why it's throwing me off. Where the court just has to rely on the allegations made in the complaint. So that's the deal. So this case was cited for the sole principle that it's not the court's task to scour the record in search of a genuine issue of triable fact. So yeah, Chile, by expanding the scope to the entire case, takes things out of context, because summary judgment is not the same thing as a motion to dismiss. Here, this is not a summary judgment, and all the facts are to be weighed in my favor, and the court doesn't have to search for ones that are disputed. Not all facts, but if they could be reasonably interpreted in your favor. So yeah, but you actually have to allege facts that, if true, would put the case at issue. And again, the issue is that stating a conclusion, like I was assaulted, sounds like you're stating a fact, but it's not. It is not a fact. It is that it would be a conclusion. As applying to a motion, LVMPD cites this case. So just because they're citing these cases doesn't mean it's necessarily something that you're going to have to file or apply to, especially if your apply is that shitty. See also this case, which applied Keenan on a motion to dismiss. So Arisman versus Woodford, is that what we're talking about? As applying to a motion to dismiss. So Arisman versus Woodford merely says that the logic in Keenan versus Allen applies to a motion to dismiss, which seems pretty self-evident that it would. There, the court defense both told plaintiff that he must attach a declaration saying that he exhausted a retaliation claim. That must be another EEOC case, I'm going to guess. Well, it probably won't be available, but let's just try it. Let's just try it. Let's see if it's available. Sounds like an EEOC case. Nope. This is a prisoner case where you'd again have to exhaust the administrative process. All right. Okay. Plaintiff failed to attach a declaration. The court said it wasn't going to search voluminous evidence in the record. The court did not say that it would not look at the facts alleged in the four corners of the complaint. Here, the facts are alleged in the complaint. Well, the court's going to get to figure out if that is in fact the case. New facts pled. LVMPD newly argues that I, quote, offer no new facts he could plead, which is inaccurate. I say that I could plead that the gun was pointed at my head if it was not clear in the complaint. Although it seems irrelevant, other than LVMPD alleges that the case law shows it is clearly excessive force if it was pointed at my head, regardless of the other facts. What case law and where? The mere fact that the gun was drawn or pointed at my head does not prove excessive force. Excessive force is a question of fact based on reasonableness. Even the drawing of a gun without it being pointed at my head, although it was, could be excessive force, even though LVMPD's side of the case would be less relevant. That'd be tougher. It'd be tougher if they just had their gun drawn and weren't pointing it at you. But even then, yeah, it would be a question of fact. Recording a police encounter. LVMPD newly argues that I pled no facts suggesting I was arrested for filming a public police encounter. This is inaccurate. The facts clearly indicate I was recording a police interaction. Yeah, but again, it's conclusory, saying I was recording the police and therefore they arrested me for filming them. That's conclusory. You're not stating like they said stop filming and I said no, I won't stop filming, and they said if you don't stop filming then we will arrest you, and I said you can't arrest me because I'm doing a First Amendment protected activity, and then they arrested me. Those are facts. Saying they arrested me for filming is a conclusion. It sounds like a fact. It's a conclusion. 1981 claims. LVMPD newly argues that 1981 claims must be filed as 1983 claim against a state actor. As many arguments of LVMPD's motion to dismiss a mistake claims against individuals for claims against LVMPD in the complaint. And where does he reply 8-6? Where are they arguing this? There's no citation. Let's see if we can Google it. What's the date? 2023 Ninth Circuit en banc. Ninth Circuit en banc. Interesting. That seems pretty clear. So what Chile or Floyd should be arguing that based on this new opinion that was filed July 25th. When was Wallace filed? So Wallace filed his complaint prior to June 25th. Let's show this tab instead. So he filed his complaint May 24th. So after he filed his complaint, new case law came out that overturned existing case law that said you can't plead a 1981 cause of action. Well, you can plead a 1981 cause of action, but you can't get a remedy. So you have to plead it as a 1983 lawsuit. So because it overturned existing case law that was in existence at the time he filed, the court, what he should argue is that the court should allow me to amend my complaint to plead this as a 1983 claim. That's what Wallace should be doing instead of being a dumb shit. So instead of actually reading the citation, which makes it clear what they're talking about, he makes some dumb shit reply. They mistake claims against individuals, claims against the LVMPD in the complaint. Manel claim requirements. LVMPD newly argues that since plaintiff offers no new facts, he could plead to support his claim that my claim automatically fails. No new facts are required. It identifies a challenge policy or custom, explains how the policy caused me harm, complaint at 49. I would probably doubt that. Let's look at the complaint at 49. As a result of their actions, what the fuck are we on about? identifies challenge policy or custom that's at 50. If the defendant's behavior did not follow their use of force policy in interactions with public policy. So he's saying at 50 that they did not follow the LVMPD's policy. I think I remember pointing this out. I'm like, you just fucked your own Monell claim. I remember pointing this out when I went over his complaint. He fucked his own Monell claim because he said they were not following policy. There's no policy there. And if there's no policy, there's no Monell claim. You idiot. The claims are sufficient for this sufficient to get your Monell claim dismissed, I guess. As mentioned, I oppose their motion as it was full of incorrectly applied laws and facts. You should really be more clear about what they are because you have not really done a good job of it thus far. My complaint should be dismissive of what LVMPD says is correct, and I didn't oppose it. You're not actually addressing their arguments. If a complaint is merely dismissed because of what is in a motion and not based on the four corners of the complaint, then I can simply refile. A Rule 12b6 motion to dismiss for failure to state a claim is viewed with disfavor and rarely granted. They're granted all the fucking time. A motion dismissed for failure to state a claim should not be granted unless it appears beyond doubt that the plaintiff can prove no set of facts in support of her claim that would entitle her to relief. Yeah, we've read all this shit. Negligent investigation. LVMPD knew the arguments of my position, makes no effort to establish this fact. Reply 916. 916. Wallace alleges the officers conducted a negligent investigation prior to his arrest. They're immune from negligent. This is a state law claim. I don't know. I don't know state law claims. Leave to amend. I don't know if LVMPD counsel is being serious here when they claim I must attach a copy of the proposed amended pleading before the court can grant him leave to amend. Right now, I'm not asking for leave to amend. I believe my complaint is sufficient. Where this court finds that it isn't, the court should grant leave to amend. I also cited case law saying this court should identify where my complaint is deficient. I can't submit a copy of the proposed amended complaint where I don't know what the court will find, where the court will find it deficient. I don't believe it's the court's job to give legal advice. Oops. I don't believe it's the court's job to give legal advice, but they will say how it fails. That is true. All right, so I have to piss like a racehorse. It's late. There's a hell of a lot of mosquitoes out here, so we're not going to do we're not going to read comments, but thanks for watching. Have a great day.